You're watching the legal breakdown. So, Glenn, we have an update from the Manhattan DA's case against Trump where the judge has blocked Trump from posting online. Can you explain what happened here?
Yeah, Brian, three words: about damn time. It is about time some judicial officer put some narrowly tailored limitations, restrictions on Donald Trump's speech and on Donald Trump's posts. Now, mind you, this is not a gag order. What this is Judge Marchand, after hearing from the prosecutors, wanting to protect the integrity of the evidence that they're turning over to Donald Trump's lawyers in discovery. After hearing from the prosecutors and hearing an argument from Trump's attorneys, the judge has ordered some limited restrictions on what Donald Trump's defense team and what Donald Trump personally can and can't do. It's funny because just yesterday, I was railing against Donald Trump's most recent post because on Sunday, he just posted something on his third-rate social media platform that had lie after lie after lie. And I decided I would continue screaming into the social media void, urging a judge to take action to put a stop to the lies, the propaganda that Donald Trump continues to throw into the public square to try to do two things, really: poison the well of public opinion generally and poison potential jury pools specifically. Real quick, this is what Donald Trump posted on Sunday. He posted pictures of Attorney General Letitia James, New York Attorney General, District Attorney Alvin Bragg, District Attorney Fani Willis, and Special Counsel Jack Smith. And he said, among other things, these are the prosecutors that Merrick Garland and crooked Joe Biden have illegally unleashed on me in order to interfere with the upcoming 2024 election. Now, it is such a provable lie because President Biden and Attorney General Garland have no authority over state court prosecutors, over attorneys general for the states. So Donald Trump is lying. He's throwing you know what in the mix. And he himself is trying to interfere in the 2024 election by putting this propaganda out there in the public square. I am so thrilled that Judge Marchand finally stepped up and said, okay, you are now prohibited from disclosing or posting about the evidence the prosecutors are turning over to you in discovery in their prosecution. You may not copy it, you may not reproduce it, you may not take pictures of it, you may not share it with third parties, and you may not post it on social media. The judge gave them an escape hatch without prior judicial approval. So it's good that somebody is finally treating Donald Trump like the dangerous child he is. And in fact, he can only review this sensitive material in the presence of his own lawyer. So at least there's somebody there to babysit Donald Trump.
What happens if, and I would argue when, he does post any of this stuff online without prior written consent?
I'm with you. I'm going with when, not if. And then, that's where the rubber hits the road, because if you violate a judicial order in your criminal case, there are, I would say, four things that can happen. The judge can say, I'm going to give you a second chance. In other words, no penalty. I think that unlikely, but it could happen. The judge could say, I am now going to increase the restrictions that I'm placing on you. Maybe now I'm going to prohibit you from speaking publicly about certain aspects of your case, which would be an expansion of the restriction Judge Marchand put on Donald Trump today. He could say, I'm going to fine you because you violated my court order, my directive. And then sort of the granddaddy of all sanctions for violating a court order is what we call step back. Step him back to the dock and give him a little taste of what's in store for him in the event he continues to violate restrictions set by the court. He could hold a hearing to see whether Donald Trump should be held in contempt and potentially jailed.
Okay. Does it bode poorly for Trump that Judge Marchand took this step, or is it going to have no bearing on the case at all?
It will probably have little to no bearing on the trial itself. Why do I say that? Because it's not like the prosecutors will get to introduce evidence that Donald Trump had these limitations, these restrictions placed on him. They probably wouldn't even be allowed to introduce to the jury the fact that Donald Trump violated those restrictions in the event he does violate them. I think the way that a jury might know something about it is if they read some news account prior to being selected as a juror. Now, that's not disqualifying because every juror will be asked, do you know anything about this case? Have you read anything about it in the media? Have you watched any news accounts? If so, and presumably most people are going to know about Donald Trump and at least some of his crimes. If so, can you agree to set it all aside, put it out of your mind, and decide this case based solely on the evidence you see produced in court during the course of the trial? Those questions are asked and those answers are given by jurors under oath. In my experience, Brian, most jurors take that oath deadly seriously. Many of them will come in and say, I can't be fair because I'm a huge Trump supporter or I'm a huge Trump detractor. Those are the kind of people who will be excused by the judge because they really can't sit fairly and impartially and decide the case based only on the evidence that is introduced during the course of the trial. But the long and short of it is, I don't think these pretrial restrictions or limitations being imposed by Judge Merchan are likely to have any impact on the jury.
Glenn, just as a quick aside, if someone really is a Trump supporter and they have a vested interest in making sure that they do end up sitting on that jury, what's to stop them from lying about their political engagement, about their political persuasion, just to get on that jury so that they can then be there to protect Donald Trump once the case actually goes to trial?
Hopefully, the oath they take under the penalties of perjury and contempt, if they violate it, will motivate most people to tell the truth. But, I can tell you a story about a case we had in D.C. where during jury selection, the potential jurors were asked, do you know any of the parties? Do you know the prosecutor, the defense attorney, the defendant? And there was a woman who did not answer that question, indicating she didn't know anybody. It turned out that was a former girlfriend of the defendant who was on trial for murder. And then she started to play games when deliberation time came. So she actually ended up being prosecuted for contempt and for perjury. So most jurors, I think, take that oath very seriously. Here's the other thing. If the parties, the prosecution and the defense, know the identity of the jurors, know their names, know who they are, which is not a sure thing, because remember, in the E. Jean Carroll civil trial, the jury is anonymous. So the parties don't even know the names of the jurors. That's unusual. It happens from time to time. But if the parties know the names of the jury, well, they can Google them. They can research them on the internet. And most people, if they have those kind of strong political leanings one way or another, the parties are going to be able to discover that and act accordingly. And let me tell one more story. You may remember during the Paul Manafort trial, of course, Manafort was Donald Trump's campaign chairman for a period of time in the 2016 campaign. There was a woman on the jury who was a self-described MAGA. She said, I wore my red Make America Great hat to the trial every day. I took it off, left it in the car. I sat as a juror in Paul Manafort's criminal trial. At the end of the day, I got back in my car, put my MAGA hat back on, and I went home. I am a huge Trump supporter. I didn't want to believe Paul Manafort was guilty or did anything wrong because I associated him with Donald Trump. She said, but the evidence proved Paul Manafort's guilt beyond a reasonable doubt. So I had to vote in favor of conviction. That gives me those justice goosebumps as a former career prosecutor, because that is how, in my experience, most jurors approach their jury duty responsibilities.
Well, there you go. Now we know how to deprogram these tens of millions of Trump supporters. We just got to get them individually on bench trials in front of corrupt Trump officials so that they can get individually fed all of this evidence that proves how guilty they are. Glenn, was there some inciting moment that caused Judge Merchan to take this step against Trump, this social media gag order, if you will? Because presumably Trump's history of targeting witnesses and trying to basically go online and make his case in the court of public opinion isn't new. So why now?
I think it was the cumulative effect of everything Donald Trump has been doing to endanger prosecutors and their family and their staff, to endanger judges and their family members, to endanger grand jurors, to endanger trial jurors, to endanger witnesses. I think it's the cumulative effect. And I think maybe finally it's all catching up with Donald Trump. He's gotten away with too much for too long. And I feel like some of the chickens are going to start coming home to roost.
Okay. Now let's leave it off with this. What is happening in the Manhattan DA's case right now, since the next pretrial hearing isn't scheduled until December? So what is this period that we're in right now?
So this is the discovery phase. So the prosecutors are delivering to the defense, about to, I think now that they have some restrictions and limitations in place before they begin turning over all of the discovery. But now they're going to start giving over to Donald Trump's defense team all of the evidence they're required to give over by the rules of discovery and by the Constitution, which requires, for example, anything that's exculpatory, anything that's helpful or could exonerate the defendant. The Constitution says under the Brady case, the prosecutors must package all that up and give it to the defendant so he or she can use it to defend themselves at trial. I embrace the Brady rule. It's one of the great things about our judicial system. All of that is now in the process of being given over. And then motions will be filed after the defense has had time to absorb that information and see what kind of motions they might want to file. For example, challenging the admissibility of some of the evidence that the prosecution is now giving them. So there is this legal dance that will go on for, unfortunately, several months before the next court hearing in December. And then I suspect sometime soon we're going to hear about a firm trial date being set. It is likely to be hopefully not well into 2024, but certainly into 2024.
And just as a quick aside here, do we expect Trump to be present in that case as opposed to the E. Jean Carroll case, where, of course, he didn't bother to show up?
You know, a civil trial and a criminal trial are two very different animals. A defendant not only has a right to be present every minute of his criminal trial, he has an obligation to be present every minute of his criminal trial, unless the judge takes the extraordinary step of excusing the defendant's personal appearance. That almost never happens, but of course, with a defendant who is a former president who's running for office again, hopefully, you know, he will be treated the way you or I would be treated if we were criminal defendants, but it wouldn't shock me if there were some special dispensation shown to him by the judge so he can, you know, go out and campaign and hold his hate rallies and do what he ordinarily does. But the default is that a defendant in a criminal case must be present every minute of the proceedings.
Okay, and as soon as obviously we have more information on how that trial will play out, we'll come right back to you with another episode on that one. So if you're not yet subscribed to these channels, make sure to subscribe. The links are right here on the screen. I'm Brian Teller Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.